Hello. In this recording of our Justia webinar, From Gray Areas to Guiding Principles, Ethics in IP and Patent Law, Emil Ali provides an overview of the ethical framework governing USPTO practice, including the authority of the OED, the duty of candor and good faith, risk tied to conduct, and concerns in IP ethics, offering guidance for compliance and professional integrity. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Thank you, Nina. Thank you so much. As you heard, today we're going to be talking about ethics for mostly patent lawyers, but I'll try to include a little bit more about general IP, including trademark law as well. I'm excited to be here. Some of you may have seen some of my presentations before, but for those of you who have not seen them, I want to start out with a quick agenda. And one of the first topics that we're going to talk about is the USPTO's regulatory power, as well as the role of OED. And I think this is important. While many patent lawyers probably have heard of OED, they don't always remember it. And I think it's helpful to understand as we frame what these gray areas are, we'll frame them in the eye of, well, what rules apply to them. We'll also talk about very important candor obligations and how those candor obligations, like your duty of disclosure, connect to things like inequitable conduct. We'll also talk about conflicts of interest, and especially those stubborn subject matter conflicts, as well as the use of AI. And as Nina mentioned, I'm happy to take questions as they come along, and I'll also leave some time at the end for those questions. So a lot of people ask me, well, how do we know if we're practicing patent law or practicing trademark law? How do we know that we're practicing before the USPTO? And the simple answer is that it's not very easy. So if I physically go into a state and I practice, law, I am engaging in practice within the state's borders. With the USPTO, you could be in California, New York, London, or Timbuktu, and you could be engaged in practice before the USPTO and therefore be subject to their jurisdiction, which we'll talk about in a moment. But it's helpful to understand that 37 CFR 11.5 talks about practice before the office, and there's B1, B2, and B3 that talk about practice in design patents, practice in regular patents, and then practice in trademark matters. So what exactly is practice before the office? Well, according to the USPTO, and this has not actually been tested very heavily, but it is any practice that includes the presentation of a paper to the USPTO, which makes sense, but also giving advice in contemplation of filing something. So why is this important? Most of you in the audience are probably registered patent attorneys and probably are eligible to practice before the USPTO. But some of you may also work with individuals who are not registered to practice in patent matters before the USPTO. If one of your colleagues who is a trademark attorney, for example, says, hey, you should have a consult with my colleague, Joe, totally fine. But if that individual says, before you have a consult with my colleague Joe, here is my advice to you about filing a utility patent application. That may be practice for the USPTO in patent matters and may be the unauthorized practice of law before the USPTO. So it is helpful for you all to pay attention to this, even if you are registered, to understand what the nuances are of practice. Well, why does this all matter? Because when I practice before a state agency or a federal agency, let's say I wanted to practice before the IRS or the Social Security Administration, I'm doing so because the Administrative Procedure Act allows me to do so. It regulates the practice of law before federal agencies. As members of the bar of any state or territory, you can practice before the IRS, Social Security Administration, heck, any of these alphabet soup agencies. But, and also before the USPTO and trademark matters. But what you cannot do is practice in patent matters before the USPTO unless you are registered. And that's because the USPTO was given statutory authority under 35 USC 32B to establish regulations governing the conduct of agents, attorneys, etc. And they have done that. They have created these regulations and created restrictions on that practice. What's not listed here is 35 USC 32 also allows them to discipline lawyers. It allows them to regulate the conduct through discipline as well. So they can enroll you and then potentially discipline you. And again, this is how they are eligible to regulate the practice of law and create this extra restriction. It also means that you are subject to the USPTO rules of professional conduct if you even file one trademark application. Even if you've never filed a patent application, but you took the patent bar, you are subject to those USPTO rules of professional conduct, including reporting if you've ever been convicted of a crime, things of that nature. But it's helpful to know that those USPTO rules are very similar to the ABA model rules, which are applicable in all 50 states, the District of Columbia, and of course, the USPTO. And OED is the office that investigates this. Think of it like the Office of Chief Trial Counsel in California. But many people are not aware of it because they don't really interact with them on a regular basis. But before I get into OED, a lot of people say, well, now that you've told me that there are these USPTO rules of professional conduct, what rules apply to me? And what I like to do is talk about this case, Kroll v. Finnerty. Kroll v. Finnerty stood for the proposition that a gentleman named Michael Kroll, who had been disciplined or investigated multiple times by the USPTO, basically told New York, you cannot investigate me or discipline me because the USPTO rules control and only they can discipline me. That is not correct. The USPTO has concurrent jurisdiction with state bars to punish you. However, a state bar cannot prevent you from practicing law. And that's what Sperry v. Florida says. They cannot interfere with your license. But as long as they're just putting attendant requirements, like maybe they restrict certain types of advertising, generally going to be okay, as long as it doesn't interfere with your right to practice patent law. So going back to the question, what rules apply? Well, we generally look to ABA model rule or the state equivalent of rule 8.5. And 8.5 basically says you can be disciplined no matter where your conduct occurred if you are admitted to practice. And then on top of that, 8.5b says the choice of law that applies is where the tribunal sits or where the predominant effect might be. And this is where it's very important for those of you that practice before the USPTO. Let's say your state has a restriction on whether you're allowed to take money in advance or whether you're allowed to do X, Y, and Z. Let's just say about where your trust account should be. California says you got to have a trust account in California, and you're in Florida now. You're not admitted in Florida. Which rules apply? Well, the USPTO rule just says that you have to have an account separate from your own. If you're solely practicing patent law or trademark law before the USPTO, theoretically, under an 8.5 analysis, the USPTO rules of professional conduct are the only rules to apply. So if the State Bar of California was going to investigate you, they should be using the USPTO rules, which you would then say you did not file. So it's kind of helpful to understand those things as you look and as you research what the requirements are if you have a question about your practice. So, what's OED? OED, as mentioned earlier, regulates the conduct of attorneys who practice before the agency. They also do enrollment matters. They manage a patent pro bono program as well as a law school certification program. In recent days, they've unfortunately lost a lot of people with the stuff that's going on at the administration, but they have a very large caseload of a few hundred cases, investigations they work on every year. So now jumping into Candor obligations. So for those of you that are patent professionals, everyone knows Rule 56. It's the rule that hopefully we're all afraid of, but hopefully we're all at least aware of. And, Rule 56 and Rule 555 are examples of your duty of disclosure, right? So we have this duty of disclosure in re-exam proceedings. We have them in regular patent applications. We have duty of candor before the PTAB, but we also have 1118 and 303. So we'll talk about maybe the duty of disclosure obligations in just a second, but let's start with the basics. When I sign, file, or advocate for something, I'm putting my name on it. I'm putting my reputation on it. So I want you to remember back in law school, for those of you who are not litigators, Rule 11 of the Rules of Civil Procedure. When you submit something to a judge, you're saying that you've read it. You're saying that you stand behind it. It's the same thing when you go to the USPTO. So 11.303, based on ABA Model Rule 3.3, and there are some changes to it, by the way. Basically, my summary of it is thou shalt not lie to the US or lie to the court or lie to the tribunal, and don't present false facts or false law. Easy enough. If I asked any of you in the audience, will you lie to a court? You'll say, of course not. My client tries to get me to lie. I'm going to withdraw. So let's take a moment to step back. What is the definition of a tribunal, both under 1118 and 11.303? So we're not supposed to, submit false information or lie, etc., to the tribunal. Well, under the USPTO's version of the rules, they define tribunal to include the USPTO. So let's take a moment to just level set. We cannot lie to a judge, but who is the patent examiner? Who is the trademark examining attorney? They are not our friend. They are not our opposing counsel. They are not our colleague. They are the quasi-judicial officer. So when you sign, file, or advocate for something, you're submitting it to the judge. When you present evidence in a patent application, trademark application, whatever, of course, before PTAB and TTAB, you're submitting it to a judicial officer. So you'll all remember the Andrew Schroeder case where he asked the patent examiner if they were drunk, things like that, and got suspended, I believe, for 6 months. That's an example of something you can't do, right? That's civility and respect. But also, you have a duty to double check your work. And that's what Rule 11 or 1118 stands for. And same thing with 11.303. We don't want to present this false information. So again, how does this apply to non-patent folks? Don't put your head in the sand, right? When you're filing a specimen in a trademark application, got to make sure it's correct. On the patent side, 11.303 also connects to the duty of disclosure obligations. So you have a duty to disclose information material to patentability. And if you don't, there could be an allegation of inequitable conduct. And we're going to talk about inequitable conduct in just a moment. But circling back, let's think of an example. When we think of candor with respect to the trademark side, that's sometimes a little bit simpler. It's a very short process. Trademark filings have something called a verified statement. The verified statement is a declaration under penalty of perjury, 18 USC 1001. The practitioner is making a certification, whether they sign it or not. Many of you that have heard me talk before probably heard me say that it's probably better for the attorney not to sign unless they have personal knowledge. They can sign, but it's probably better to not sign. But even if you have your client sign the declaration saying that they're using the mark in commerce, you better make sure it's a reasonable basis, right? If your client comes to you, so a small company in China says they want to file a trademark registration for, LG with that little, smiley face, that's like a G. And they come to you and ask you to file that. And they're a small company in China and they're asking you to do it for displays and TVs. You probably don't have a reasonable basis to file that, right? Because your company is not the same LG. So it's very, very important for you to think about those things before you submit that. So am I saying that you need to fly all the way out to your client in China, Florida, wherever they might be? No, I'm asking you to think as you do that Rule 11 basis. Who is my client? Are their client representatives sophisticated users of legal services? So if my client is in-house, or my client is a company with in-house counsel, and that in-house counsel has used my services for a number of years, it's going to make me feel more comfortable with their ability to understand what I'm talking about. However, if it's a, garage tinkerer that's never hired a lawyer, I probably need to spend a little more time explaining to them certain terminology because I want to be comfortable that they understand what I'm talking about. And most important, record keeping. If you've ever seen me speak before, if it's not in writing, it never happened. And I'll say that again. If it's not in writing, it never happened. So if you say to me when I'm defending you that I was able to verify information based on what a client told me, I will say, show me. And you'll say, oh, I looked at the Amazon link. I looked at all these different things and was able to verify this. I need to be able to show that you did that. And to show that you did that, it would be helpful to have some sort of records. So moving on to inequitable conduct. I don't want to kind of brief this whole case, but one of the most important cases in the lineage of inequitable conduct and this idea of unclean hands was Hazel Atlas. Hazel Atlas was a Supreme Court case from the 40s, and it basically dealt with rejection at the USPTO, where back then the attorneys were trying to get a patent granted for a method of making glass. So the patent attorneys got a rejection and then drafted an article that they thought they could use to show that their specific process was novel, some sort of support of patentability. So they went to an expert in the field and said, hey, can you take a look at this? That expert adopted that article that wasn't written by him, it was written by the patent lawyers, and then basically put his name on it. They submitted it to the USPTO, and ultimately the office reversed itself and granted a patent. A couple of years later, there was some infringement litigation, and later the opposing party learned about this issue and they brought it up. It went all the way up to the Supreme Court, and the Supreme Court held that the patent owner was barred by unclean hands, right? The precursor to this full idea of inequitable conduct. And what they said was the attorneys had engaged in a deliberately planned and carefully executed scheme to defraud not only the USPTO, but the Circuit Court of Appeals. And, they said this calls for nothing less than a complete denial of relief for the claimed infringement, and the patent thereby procured and enforced. Where are we today? So now we have Rule 56, which, has had some ups and downs. We've got TheraSense. We've got so many things that have happened. But I want to go back to something Judge Newman said in a dissenting opinion in the Promega case back in, I think it's 2003. She said that there's been such an overuse of the allegation of inequitable conduct, the affirmative defense, that the prevalence and accusations of inequitable conduct in patent cases lead judges to suspect that all scientists are knaves and that all patent attorneys are jackals. It's a really interesting perspective to put on this. But why do we think that inequitable conduct is such an important consideration in patent law? And frankly, the answer is it's the atomic bomb of patent law. That's the quote that Judge Rader said back in 2008. And I think he's right, because if you look at how it can infect related patents, it is remarkable, right? It's clear that a finding of inequitable conduct in one application can spread obviously down the lineage to all continuations, child, whatever you want to call it, but it also can spread horizontally. Imagine if an inventor was accused of lying to the USPTO in one application. If you are the litigation attorney, you're going to say that that inventor has a propensity to lie. So we're going to look at every single application this inventor has ever worked on, and we're going to say that every one of them is barred by the doctrine of inequitable conduct. And imagine how difficult it is to overcome that. And, beyond that, we're also thinking about if a practitioner is involved. If a patent attorney or patent agent's involved, then every single patent that they've worked on could be, again, depending on what the considerations are, could be subject to those issues. So we know that with TheraSense, we have intent and materiality, and, we have those key elements, and we have that but-for standard. And even though there's a higher burden of proof, it does not mean that inequitable conduct has gone away. Because for a while, pre-TheraSense, I know that we had inequitable conduct being thrown out everywhere. But if you look, it's still being argued, or at least put forth in affirmative defenses in a number of cases. And there have been continuous findings of inequitable conduct. And I want to go with a quick example from 2021. This is the Hatch-Waxman case. And in this case, there was a gentleman named Mr. Rubin, who I'm going to just comment is not a patent practitioner, not an inventor. He was the chief science officer of the patentee. So there was some information that was alleged to have been withheld from the USPTO, but provided to others, including the FDA. Basically, like a journal article, as well as information about two prior companies' similar formulation of epinephrine. And during trial, there was evidence that came through showing that they had told the FDA that the racemization of the drug, which is a consideration in the formulation, was a very well-known process. And they'd cite the journal article, which they did not give to the USPTO. If you think about it, they want to tell the FDA, this is new, this is not new, this is normal. I don't want to have some extra approval process, just approve this normal process that we use. But they need to tell the USPTO that this is new and novel. So there's some competing interest there. They also told that the FDA that I think there was some sort of a process pH change was very minor compared to the manufacturing process for the two formulations not disclosed to the USPTO. Well, the Federal Circuit agreed with the district court and found that this specific withheld information was material to patentability, and they specifically said it would have blocked the issuance of the patent. That's some strong language. And they basically said that Mr. Rubin had acted with deceptive intent because he was an active participant in the FDA approval process. And also he was part of this, USPTO team process where he was working with the attorneys, et cetera. So together, they said the patent was going to be enforceable, and Mr. Rubin was called out in the Federal Circuit report. So why is this important? You all are patent practitioners. And as patent practitioners, you all probably are saying, well, did an attorney get in trouble? And the answer is no. I have not seen an attorney being accused of doing anything wrong. But I think this is a lesson to go back to your clients, to cite this case and to bring it to their attention and say, listen, client, especially the sophisticated clients, I work with a lot of patent law firms, big and small. And one thing that I continuously hear from them is when I tell them, they'll ask me a question. They'll say, I received this, IDS package from my client and it has like 500 references. There's no way I can, read through all these references, but there's also no way that I can submit all these references. What should I do? And the answer is you have to go through them, right? You have to just make a determination because otherwise the IDS is going to be rejected. There's obviously the higher fee, et cetera. And they're saying, we don't have time in our budget. Our budget has remained the same for the past 10 years. There's no way that we can do more work for less money. And I appreciate that, but that's why this is important. This is important to show your client that you are trying to build the strongest patent possible to try to protect the company, their constituents, and the patent portfolio. You're going to tell them that I need, as your counsel, your patent counsel, to be aware of what the product team is doing, what the marketing team is doing, what the regulatory team, what the sales team is doing, the FDA team, whoever it is. And I need to be able to be in that room with people, which means that I need to potentially charge more for the work. Because again, we're not just trying to procure a patent that's going to be deemed to be unenforceable and infect everything else. We want to build the strongest patent possible. And I think it's worked with many sophisticated companies that are saying, wow, we never thought about it that way. Whether we're trying to get approval of a new, road testing technology for self-driving cars, or, whether it's a drug issue, medical device issue, anything where there is some level of communication with third parties, even funders, right? If you're looking for investors, there's certain things that you want to make sure you don't say to the investors if it's going to potentially be something that's going to be deemed to be a false statement or a statement that's not, at least not accurate. So why else is it important? So I gave you the business mindset of it, but what about the ethics issue? So I want you to think for a second. If a district court, or obviously the appeals court and even the Supreme Court, finds an allegation of inequitable conduct, or even makes that allegation, it pretty much results in a referral to the USPTO's Office of Enrollment and Discipline. And a finding of inequitable conduct is almost a death sentence, right? But the question is there any way to solve that problem ahead of time? So I want you to think for a moment. Who are the parties in a patent litigation? So you have potentially a patent owner and you have somebody accused of infringement. The Patent Prosecution Counsel is generally not going to be the same counsel that's doing litigation. That's not necessarily a good idea. But beyond that, that prosecution counsel might be a necessary witness for that allegation of inequitable conduct, might be deposed, might be all those different things, but they are not a party to the case. So how do you fight this allegation of inequitable conduct? So let's walk that through a hypothetical. So patent owner sues technology company for patent infringement. The technology company, as an affirmative defense, raises the allegation of inequitable conduct by the patent owner and their counsel. The district court finds inequitable conduct, and both patent owner and prosecution counsel want to mitigate losses. They're like, you know what? I don't want to deal with this. Let's just move on. We've lost. Let's go. 2 months later, OED investigates and asks prosecution counsel about the district court finding, and they request objectively privileged and confidential information. And let's say there was no privilege waiver. What do you do? So here's some questions. What can you as prosecution counsel disclose to OED? And what should you disclose? Is the client the one that's complaining about you? Did you do anything wrong, right? Does state law, think California law, trump the USPTO rules as it relates to confidentiality, because it's statutory in California, for example. And then what if disclosing this information can further hurt your client, right? Maybe you have evidence that you found out later that your client did something wrong, but is that something that you can go tell on them for? Depends on when you found out about it, right? These are really, really important considerations. But the one thing to think of is, how can you prevent this? You're not a party to the case. You could convince the patent owner to fight this and say, listen, my reputation's on the line. I think we need to fight this. We need to figure something out. And maybe my insurance company will help fight for this. But I want to take a moment to remind everyone, if it's not in writing, it never happened. So I know there's a handful of boutique patent law firms that have gotten some advice that I don't agree with. And that's this idea of what they call clean files. When a patent issues, some people say, oh, well, we should delete all our communications with our client and only keep a copy of the granted patent or not keep anything at all. I believe that is a very, very bad thing to do, because essentially what the idea behind that is, they won't be able to find inequitable conduct if they can't find any sort of work that's done. That's not the case. Remember, a communication involves two parties. Somebody has a communication and they say, hey, here's a bunch of documents that, we wanted to make you aware of as part of our duty disclosure obligation. And then we find out that information was not sent to the USPTO. Now we have an allegation of inequitable conduct. Well, maybe there's a memo to file, hopefully, that the lawyer wrote saying, I looked over these things and I believe they were not material to patentability. That would be very, very helpful in a defense of inequitable conduct, right? That goes against the intent aspect of it, and maybe even potentially some analysis of materiality. But because of this clean file perspective, there's no communication that's been saved. There's no memo to file that's been saved. So I ask that, if somebody, a non-patent ethics person gave that advice to your firm, I ask that you consider whether that advice really works in the construct of the USPTO and IP ethics. So I want to jump to another case, and this is GS Cleantech v. Adkins Energy. This was a case that was denied cert at the Supreme Court, and I don't want to go through the whole timeline here, but the patent suit here were directed to the recovery of oil from a dry mill ethanol plant's byproduct. That byproduct is called thin stillage. So these dates are very confusing. So I'll just kind of briefly tell you that August 1st, 2003, an inventor emailed a proposal dated July 2003. Okay. So emailed a proposal dated the date, and it was considered to be an offer to purchase or offer for sale. So then there's August 17th. Over a year later, a provisional application was filed, and that set a potential on sale bar date. Over a year, or in this case, it would have been the year earlier, but it was still after August 1st. Then Mr. Duricio filed a non-provisional. Then there was a transfer of the case to Cantor Colburn. We all know Cantor Colburn. Then a potential investor sought some information, blah, blah, blah. Inventor had signed a document from July of 2003. So we fast forward, the inventor provided them with a signed copy of that July 2003 offer, right? July offer. Okay. So Cantor Colburn says, hey, USPTO, in compliance with my obligations, here's an IDS. And again, this is pre-AIA. So, we're swearing behind it and providing all this information and saying it was hand delivered on August 18th. And I think that's really, really important. August 18th. We're thinking August 18th because of August 17th. Is that potentially why? And, it's not on the slide, but part of the issue was, I think there was some reasonable basis to assume this because I believe that the inventors had provided a copy of like a parking receipt showing that they went to the headquarters for Agri Energy on August 18th. So there was like a parking pass. So it was reasonable for them to believe it. So Cantor Colburn filed a second declaration saying that the inventor had forgotten about sending this. Well, again, the attorney submitted these affidavits on the on-sale bar, but the court said no. The attorneys failed to ask the necessary questions of the inventors, and they put their head in the sand. Well, how did this come through? Well, what they said was that the July 2003 proposal was made before August 17th, right? August 1st. And that it contained major elements for a contract for the sale that could perform the patented method, all items necessary to recover oil and the price. So what they ultimately did, after the bench trial, the district court determined the patents were unenforceable due to inequitable conduct. And the court determined the inventors took affirmative steps to hide that July 31st, August 1st offer from their lawyers. Then later from the USPTO, when they learned about the on-sale bar issue. So let's take a moment. Your client is lying to you as a lawyer. Not your fault, right? Let's see what the district court said. The court said Cantor Colburn either purposefully evaded disclosing to the USPTO or failed to seek out relevant information. They basically didn't ask the right questions or intentionally lied to the USPTO, so they participated in inequitable conduct, choosing advocacy over candor. I did not love this case. So CleanTech submitted a petition to the Federal Circuit, ever hearing en banc, and that was based on a procedural issue. And our firm actually filed an amicus to the Supreme Court, which denied cert. And it was an abuse of discretion standard issue. But ultimately, I think that the judge here claimed omissions. Unfortunately, the judge actually passed away in September 2017, about a year after his order. But the court explained that Cantor Colburn didn't ask the inventors key questions, and the focus on the pre-critical date documents was purposefully narrow, and they didn't identify these red flags waiting before them. None of us were in the room. We wouldn't know. But when I look at it from potentially an objective perspective, I say that yes, there's always better questions you could ask. Hindsight is always 20/20, but it's hard to say that somebody did or did not ask the right questions. But if somebody comes to you with parking receipts saying, "Hey, I went on the 17th," why can't you believe that, right? So this is a very, very tricky and difficult situation for lawyers to be in because it puts us in a situation where we're basically being told if our client lies to us, our job is to ask better questions. And that's unfortunate in terms of, the way we as patent lawyers need to operate. We need to be able to rely on our clients and rely on their statements. So I mentioned earlier about 1118, again, similar to the Rule 11 duties. But one thing people ask me is, can I rely on what my client says? And I just told you in GS CleanTech that lawyers got essentially called out by the Federal Circuit and District Court for listening to their client and not asking the right question. Ultimately, though, you need to decide what is reasonable under the circumstances. It's very, very fact intensive. Right now, I'm in Southern California and it is 71 degrees right now. If somebody that's in California, maybe 10 miles away, calls me and tells me that it's raining, I need to make a determination. Is that material? And then two, can I verify that? Can I look outside and presume it's not raining? Can I Google the weather in that particular city and make an informed decision? And then I have to decide whether I want my name connected to that. And I know it's very simplistic to say it like that, but I want you to think for a moment. When a client says that they have done something, that they are the true inventor, what sort of analysis have you done? So when it comes to inventorship, that's a great idea to kind of consider. When I put in the inventors and file the oath and declaration in a patent application, I want to make sure that I've asked the right questions. Are there any missing inventors? Have I warned the client that submitting false information about inventorship is a problem? It could lead to a potential finding of invalidity. It could cause other issues. So I think it's helpful to have that discussion with clients, even if it's only like a standard document that tells people, hey, when we submit things to the USPTO, you need to make sure that it is accurate in what you provide to your counsel, but also counsel may ask you to support any considerations you have. So if you say something, we may ask you for support and documentation. So we also talked about 11.303, the candor to the tribunal, rule. This part of the rule, paragraph A, is very similar to the model rule, but basically we can't make false statements of fact or law, and we must correct those if they were previously made. And then for certain proceedings, we must show adverse legal authority, and that duty depends if there is opposing counsel. This is slightly different than the ABA, but remember, there's no opposing counsel in a patent or trademark filing because those are considered ex parte. And of course, don't offer false evidence. These are the allegations against Cantor Colburn in the GS Cleantech case. But there's more. Under 11.303, there's also sections, B, C, D, and E. So B is not common in patent prosecution or litigation, but it's pretty self-explanatory. And C indicates that your 303 obligation trumps your 1.6 obligation. So as it relates to paragraphs A and B, this continues to the conclusion of the proceeding. So until the patent is issued or the trademark is granted, and applies even if compliance requires disclosure of information protected by 11.106. This is a very, very difficult issue. So if your client lied to you, so if you found out during the pendency of that GS Cleantech application that the inventors were lying to the USPTO, you have a duty to correct that. You have a duty to correct the false statement until the patent issues. After the patent issues, technically, you don't have a duty to potentially report that or fix that. But there might be, in certain cases, the availability of withdrawal. The USPTO doesn't like that, but the Federal Circuit in Mullins v. Textron has said that the withdrawal may be the best opportunity. D is, again, the examination issue. If you're in an ex parte proceeding, which includes a patent prosecution, trademark prosecution, you have a requirement to provide information known to the practitioner, again, that's material to patentability or otherwise, that allows them to make an informed decision. Doesn't matter if those facts are adverse. And of course, paragraph E is a very USPTO specific paragraph. It requires disclosure to comply with all your duty of disclosure obligations, including Rule 56, Rule 1.555, 1.740, 1.765, and 1.933. So I want to go through a hypothetical, and this hopefully everyone can read it, but a practitioner represents Innovatech Solutions, a startup client seeking patent protection for some data encryption. During her thorough prior art search, the practitioner discovers a recently published academic paper from a European research institution that discloses a very similar encryption technique. While the paper doesn't describe the exact same combination of steps claimed by Innovatech, it clearly anticipates several key elements and raises significant questions about the novelty of the invention. Practitioner, who is correct in her analysis, informs Mr. Chen, the CEO, about this, let's call it problematic prior art. Mr. Chen is like, no, I'm a business person. I'm trying to get money. And if we don't raise enough money, we're going to go out of business. So we're trying to launch our product. Just downplay it. Hey, you know what? Don't bring it in the USPTO's attention unless they ask for it. If they ask for it, then we can address it. But right now, it's in a different language. No one's ever heard of it. They're probably not going to find it. Just try to figure something out and deal with it. Practitioner says, no, that's not what I learned from this ethics CLE. She knows that the USPTO rules of professional conduct, Rule 56, 37 CFR 18, all that required candor and good faith, including a duty to disclose information material to patentability. And concealing this prior art would be a violation of those rules that could have severe consequences for her license and for her client and their patent portfolio. She went back to David Chen and said, hey, we really need to do this. And now she feels trapped between her ethical duties and pressure from her client. I will tell you this hypothetical is real life for all, my clients. People come to me with this specific issue all the time. What is the right answer? There is no right answer. I mean, there's a lot of different options, and I think you have to go through them. And I wouldn't say they're in any sort of linear order, but there's like a step-by-step process that you want to go through. So you want to think of Rule 56. You want to think of 11.303. You want to think of 11.18. Right? You have these duty. You objectively have a duty to disclose this information from the academic paper to the USPTO, generally in an IDS. So firmly but respectfully tell Mr. Chen, hey, concealing the prior art would be a violation of our ethical duties as practitioners, but also your duty under Rule 56, the inventor's duty under Rule 56. And we have this duty. Maybe also provide an analysis of the prior art. So to make sure that there's a real detailed analysis showing how it anticipates or renders obvious that invention and, explain it to them. A lot of people will say, well, don't put that in writing because it'll be used against your client. Well, if you think about it for a second, we're trying to protect the client here. The client is not Mr. Chen. It's Innovatech. But also, we're trying to make sure that we don't get sued for malpractice, that we don't get into any ethics issues. So we do want to show, if we believe that this information is material to patentability, we need to provide that analysis. Of course, under attorney-client privilege, but we should provide it. And then also, maybe there's some strategies that you can provide. Maybe you can narrow the scope of the claims. Maybe you can distinguish the invention. You probably cannot file the IDS without a client's permission at that point, but maybe seek advice of ethics counsel internal to your firm or a senior partner to get some other tips, because maybe there's something you didn't think of. Maybe another attorney will look at this and say, you know what, it probably doesn't need to be disclosed. But, these are all considerations you have to have, but you definitely want to document all communications. But if all else fails, if the client insists on a course of conduct that you believe would violate your ethical obligations and your duty to the USPTO, you may have to withdraw. You may have to file a withdrawal at the USPTO, and potentially, depending on the circumstances, you may need to make what's called a noisy withdrawal. Really depends on the extent of those circumstances. Because in this case, you might be in conflict with your client. So speaking of conflicts, I'm going to jump into conflicts of interest. So I like to put like the first 3 bullets on every presentation I do regarding conflicts. I also use it in my law school class where I teach conflicts, because I think this is a very simplistic way to say it. Sometimes when I talk to law students, they tell me, well, why we don't need to learn conflicts, because conflicts are for people that have problems. And I kind of say conflicts is actually something way different. Conflicts are everywhere because if you are good at what you do, you will have conflicts of interest, right? If you're a divorce attorney, you have conflicts because maybe everyone, like both spouses, are going to try to retain you, right? Because you're that good at what you do. If you're a patent lawyer, if you're specialized in a technology area, everyone wants to go to you because you're a specialist in that technology area. But most importantly, If you have a conflict or a potential conflict, clients will often sign waivers. Many people are afraid to even ask for a waiver. And I think it's helpful to know that you are not alone if you think that. But I believe it's helpful to understand that people do actually sign and agree to these waivers. But a waiver requires informed consent. Informed consent confirmed in writing. And if you engage in conflicts and you don't deal with them appropriately, you can get into ethics issues, discipline. You can also be sued for malpractice. You can be disqualified. You can lose, have fee disgorgement, and of course, reputational harm. So I want to talk about the differences and types of conflicts. I'm going to say the direct adversity conflicts are very rare in patent or trademark prosecution. You're generally not going to be on both sides of the V, right? Really what we're talking about is material limitation, right? Subject matter conflicts are a subset of material limitation conflicts, where your responsibilities to your client are limited to those responsibilities to another client, former client, third party, or your own personal interests, financial interests, sexual interests, things of that nature. So is this a bad thing though? Well, as I mentioned to you, we have to think about it for a moment. Why would our responsibilities be materially limited by our responsibilities to another client? I'll give an example for a second. We represent Samsung and LG. We represent them both in displays, but we have to think for a moment. We have fiduciary duties to each of those clients. In the Samsung application, the patent office puts an office action that cites the LG application. So now in the Samsung application, we have to differentiate these two. We're going to potentially want to help Samsung by narrowing what LG's application says or their patent says. And maybe vice versa. Maybe we don't want to do that. And ultimately we want to hurt Samsung. Or we're like, you know what? We want to make sure that both get protection. So why don't we limit the claims in both, aka claim shaping? But this is an example, a very common example of why we want to try to get a waiver. And waivers really depend on the circumstances, right? Clients want you to put them first. They don't care about the other client. They want to be your number one. They don't want you to act against their interests, and they expect complete loyalty and all your fiduciary duty going to them. And we want to avoid things like ethics issues, malpractice, fee discouragement, and even things like intra-firm harmony, right? We don't want, to get pushed around and have another partner at another office say, well, you took on this client, and now my client is unhappy, right? Those are all issues. But I want to go specifically to a fee disgorgement issue and maybe even just a reputation issue. There's a case involving Shepherd Mullen, which is a major law firm. It was not a patent case, but it goes to this idea of advanced conflict waivers. In this case, there was let's call it an undisclosed conflict. And it meant that the fee agreement was deemed to be unenforceable. So the firm was representing client A on and off over time. And that was like a small city. I think they billed something like 12 or 16 hours in 1 year. They did not disclose that to the major client that had been paying them millions of dollars. So when that major client found out about this, JM Manufacturing, they said, hey, and this is the Ketam case. They said, I'm not paying you. So the firm took them to arbitration. The arbitration granted them some money. JM appealed and went all the way up to the California Supreme Court. The California Supreme Court said a conflict of interest existed and your advance waiver did not disclose the conflict. There was no informed consent. And therefore, we think that the fee agreement is void and like essentially void ab initio. We're still going to give you money. We're going to remand this back to the trial court to fashion a remedy that awards as much or as little as equity warrants with quantum merit. But at the same time, it was a message, right? Because the fee agreement was void, it meant that the entire arbitration agreement, everything wasn't in fact void. Ultimately, Shepherd Mullen actually settled this case, with JM Manufacturing, which was definitely quite helpful. It kept things out of the, public record, but it was an example of how people need to make sure that they have informed and informed consent. So some guiding principles to kind of loop this all together. I think it's really helpful to have a rubric of how to deal with conflicts of interest, especially on the patent side. Identify the clients, right? And we want to know not only the clients, but the subject matter of the representation. And this is really key because, especially in patent law, we have so many problems where you'll say, oh, well, we represented inventor so and so. No one has a conflict with inventor so and so because that's a potential nobody. But inventor so and so has a new technology for displays, and we represent Samsung and LG. And now we actually happen to represent this, small time garage tinkerer who their application is being cited in the office actions of both Samsung and LG. So we might have a conflict waiver between Samsung and LG, but what about this garage tinkerer, right? So we have to identify the clients, but also the subject matter of representation. And then we try to identify, is there a conflict or a potential conflict, right? Is it a direct adversity, material limitation, or that subset of material limitation, which would be the subject matter conflict? And if so, and if this is a current client conflict, we look at 107B 1 through 4. And obviously, if it's a former client, we look at 109. But first, I like to go through the easy ones. Paragraph 2 and 3. Representation is not prohibited by law normally, and it doesn't usually involve the assertion of a claim by one client against the other. Then we go to paragraph 1. Is there a reasonable belief that you can provide competent and diligent representation? This is generally yes, but I ask you to consider for a moment the hypothetical between Samsung and LG. You would generally want to create an ethical screen there. It's not required by the rules, but it's easier to say we have two different teams working on your patent portfolios. That's how trade secret information material to patentability, all of that will be shared with each other. So if we think about that for a second, if you're a solo practitioner, do you really have a reasonable belief that you could do that competently and ethically? And the answer is probably not. So next is the informed consent of each client, confirmed in writing. And I want to go over that for just a moment. You do not need to have a client sign a conflict waiver. What you need to have is a conversation with the client, telling them the pros and cons, and confirm that conversation in writing, confirm their consent. You can say, dear client, per our call, as we discussed, I represent each of you in these applications and I have this potential issue. We discussed the pros and cons and you confirmed that you were okay with waiving that conflict. This email simply confirms that back. Let me know if you have any questions. That confirmatory email, better than nothing. Maybe it's nice to have things signed, but they do not need to be signed. All right, we're up the last 5 minutes of the presentation. Feel free, if anyone has any questions, to put them in the Q&A. But while I'm waiting on that, I'm just going to talk about AI. I know a lot of you probably are already using AI. I can tell you that in my practice, I unfortunately don't use a lot of AI, but I do work with a lot of patent lawyers and technology companies that are using AI. And I've seen a lot of very, very interesting information, a lot of things. And I'll give you some examples of that in just a moment. But I want to have us think for a moment about what it was to use a cloud-based technology 10 or 15 years ago. So if we think for a moment about Gmail or, I don't know, like using PayPal or any of these cloud-based service providers, by 10, 15 years ago, people would have said, oh, you can't do that. Gmail, read your email to target ads. Now, if a law firm uses Gmail, yeah, we might say that's unprofessional, but it's not unethical. Same thing now with Office 365, Clio, etc. We all use cloud-based services. We all use those things. And in fact, it's somewhat more ethical to use a cloud-based service provider than have an on-premise solution that may not actually be keeping up with security patches and things like that. So I ask that you think about those things. I know that there's an ABA ethics opinion out there that suggests that you still need informed consent to use AI. I think in some ways that's correct, but in some ways it may not necessarily be accurate. I think it depends on the relationship you have with your client. As far as the USPTO's guidance with respect to the use of AI, I would say you can look at the February 6th director memo. It basically says that the existing structure of the USPTO's ethics rules apply and that you should look at 1118, but otherwise it is permissible. In terms of what we've seen about the use of AI, people are using it to review trademark specimens, get predictive analytics about refusals, what art unit something might go in, and maybe even analyze conflicts of interest. I've written quite a few blog posts about this on IP ethics law, so I encourage you to take a look at that. But I'm going to go through some of these questions that we have. So one anonymous attendee says, how does the USPTO's regulatory power compare to that of state bar associations in terms of disciplining attorneys and agents? Well, first, let me say that a lot of people say that patent agents get into a lot of trouble because they do things that are wrong. Actually, they don't. There's about 10,000-ish patent agents, and they generally don't get into too much trouble. I mean, I have a handful of investigations every year. Patent attorneys and trademark attorneys get into the most trouble, obviously the largest number. But in terms of the regulatory power, I think it's somewhat equivalent. They tend to focus more on IP specific cases, but their case numbers get higher and higher. There's give or take around 300 disciplinary investigations each year. Many of them are reciprocal, and probably the other half are kind of just client complaints. One of the biggest filer of ethics complaints right now is an attorney that works for Amazon, filing anonymous grievances. So he does that on behalf, seemingly on behalf of Amazon. A lot of them have to do with like trademark filing, attorneys who are filing on behalf of applicants from outside the United States. Another anonymous attendee asks, how do evolving technologies such as AI-assisted patent drafting impact ethical considerations for patent practitioners? I would say that I think, that technology is here to stay. It has been very, very useful in terms of I've seen a lot of clients that have been able to work more efficiently, but I think there's probably around 20 companies I've evaluated, and there are large differences with, among them. But in terms of the ethical considerations, the same rules apply. If you use a technical specialist, a patent agent, people like that, how do you make sure that what you're submitting to the USPTO is correct? 1118. If you're signing your name on it, make sure it's okay. And I think, Nina, it sounds like you might want to end this, but maybe if you don't mind, I'll answer one last question. How can you distinguish between permissible advocacy and conduct that might be deemed deceptive? That's a very good question. And I will tell you, unfortunately, it's very fact-based, but I will tell you, if it makes you feel icky, think about how it will look on paper. And you should really take that into consideration and, maybe ask a friend, ask somebody within your firm if you're in a larger firm, and try to get a second opinion on those issues. So with that, thank you so much. And feel free to connect with me on LinkedIn.
We actually have time for a few more questions.
So, what steps should a practitioner take if they discover a potential subject matter conflict after beginning representation? So I would say I often tell people that you can see those subject matter conflicts in the horizon, right? I can usually tell you that you should know if you're in the technology area and you represent 5 competitors, we're going to have a subject matter conflict. But if you don't get it because, maybe there's some other issue, you should deal with it as it comes. And it may come, for example, in the form of an office action. You get an office action, you say, oh, well, I didn't think those were 2 related subject matters. Now you got to deal with it. You got to get a waiver or potentially withdraw. And the next question is, how does OED investigate and enforce ethical violation, and what due process rights do practitioners have? That's a very, very good question. That could be a CLE of its own. OED has, I just actually heard today that a few of my old colleagues, I used to work in OED, a few of my old colleagues left, but OED had a staff of about 20 attorneys that investigate this, and another 20 support staff that do other enrollment functions, et cetera. So they investigate this, then they send it to the solicitor's office, file charges, they engage in settlements, they have litigations before administrative law judge. In terms of due process rights, you have rights under the Administrative Procedure Act for license revocation issues. I gotten people with warning letters, no action letters, complete denial of relief to the grievant. But I've also had people that have gone through trials or engaged in settlements, and we have a case on appeal right now. So there's a whole process, and you get different outcomes based on the facts. And one other question: what are the potential consequences of failing to stay up to date with the USPTO's regulatory and ethical changes? I'm not sure if I fully understand what the question is in terms of, like, let's say USPTO's regulatory changes. If you don't know that there is a change to an interpretation of a substantive rule, that could be a violation of your duty of competence. But in terms of ethical changes, there are not often very many ethical changes at the USPTO. There's standard issues. I mean, if you steal money from a client, you could be disciplined. If you, fail to disclose information material to patentability, you could be, again, investigated and disciplined. And the last question I'll take is, what changes, if any, have been made to the USPTO rules of professional conduct? And I would say not very many large changes. Their advertising rules have been cleaned up a little bit, and they now have a provision under 37 CFR 11.504 to allow fee sharing with non-lawyers if your state jurisdiction allows such. So with that, happy to connect with you all in the future on LinkedIn. But I appreciate your time. Thank you so much.
Thank you so much, Emil, for all of your insights, as well as answering all of our audience questions. And thank you all so much for submitting your questions. We want to thank you for joining us for another Justia webinar. And as I mentioned at the top of today's presentation, don't forget that Justia Connect Pro gives you access to CLE credit opportunities for webinars just like this one, both live and on demand, helping you stay informed and compliant for your requirements. Plus, you get plenty of other benefits like an enhanced directory profile, access to our AI-powered Justia chat to connect you with more leads, and a $200 credit to apply to other Justia marketing solutions. To learn more, you can go to pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.